good afternoon. Hopefully you can hear me. Perhaps somebody could just put a thumbs up if they can hear me. Excellent. Thank you. Thank you for joining Park Lane Plowden's latest Law with Lunch, which today is on the subject of costs in the Employment Tribunal. So I'm Dominic Bayne. I am head of the employment team, and I'm joined by Andrew Webster. And between us, I think we have about 40 years of experience of appearing in the Employment Tribunal. So I'm going to start by giving a brief introduction to the subject, and then we're going to take it in turns to deal with the three separate questions that the tribunal has to consider on any costs application. So Andrew is going to talk about the gateway criteria, one of which must be satisfied before the tribunal can make an order at all. Then I'm going to talk about the exercise of the tribunal's discretion when it comes to deciding whether to make an order. And then finally, Andrew is going to talk about the amount of costs. And before all of that, I'm just going to say a few things about the cost regime more generally. And needless to say, if you have any questions, please just put them in the chat function and we will try and deal with them at the end. So it should go without saying that the Employment Tribunal is a statutory regime and it can only do what the rules say that it can do. And the relevant rules are, for our purposes, are rules 74 to 84, together with the rule on deposit orders at Rule 39. One of the founding principles of the tribunal is that employees should feel able to challenge their employer's behaviour without the fear of consequences, and in particular, without the fear of having to face potentially bankrupting cost bill if they lose. So that's why the cost orders are not merely an exception to the norm, but as Mr. Justice Burton put it in the Salinas case, the rules contain a high hurdle that must be surmounted before a cost order can be made. That said, whilst the hurdle does remain a high one, our impression is that tribunals have become gradually more and more willing to make orders over recent years. So that I think I've probably made more costs applications, certainly more successful costs applications in the last 2 years than I did probably in the 2 decades before that. I'm just going to mention preparation time orders in passing. We're going to be talking about costs orders, in other words, orders made in favour of a party who is legally who is paying for legal representation, but exactly the same principles apply in relation to preparation time orders, which are the equivalent order in favour of a litigant in person. Although in practice they come up very rarely. I don't think I have ever had to defend one in practice. The only real difference is that for a preparation time order there is a prescribed hourly rate that can be recovered, and it doesn't apply to the actual final hearing itself. In terms of the procedure for making a costs application, the rules say next to nothing about the procedural requirements. The only requirement is that you make it in time and that the paying party has an opportunity to make representations. And whilst those can be either oral or in writing, in practice, it's very difficult to persuade a tribunal, in my experience, to make a worthwhile costs order without some kind of, without an oral hearing. Most of the time, you will not want to wait 28 days to make your application. You'll want it dealt with there and then at the conclusion of the final hearing. If you've had an oral judgment, it is much preferable to have the costs issue dealt with at the end of the judgment. So it's worth spending some time, I would suggest, whilst waiting for the judgment, reviewing with your client just what findings might justify a costs application, and perhaps warning the claimant that a costs application might be on its way, and they should be considering getting together some evidence in relation to means. If there has to be a separate costs hearing, then very often the cost process becomes uneconomic and just risks throwing good money after bad, because even if your application is successful, if the other party has limited means, you're going to struggle to recover more than the cost of the application in the first place. Problem is, by 4 o'clock on a Friday afternoon, after giving a lengthy judgment, tribunals are very often reluctant to embark on a costs application. The first answer to that is to point them to Guidance Note 7, which tells them that that is what they should be doing if they possibly can. The second answer is that if there does have to be a separate hearing, the requirement is for it to be before the full tribunal who heard the original hearing, and that obviously may not be a very straightforward exercise to organise. Invariably, the tribunal will ask the other side whether they've got any evidence of means, which is a factor, as we'll come on to, that the tribunal will normally take into account, and invariably they will say no. So important, I would suggest, to show that you have at least warned them that they're going to need to produce evidence of means, and then there's at least a respectable chance that the tribunal will deal with it there and then. If there does have to be a separate hearing, then at least following the President's roadmap, it should be a video hearing, so that hopefully would keep costs down. What about the requirement for a reasonable opportunity to make representations? I think there are just two things to say about that. The first is the other party doesn't need any warning. All that the rules require is that they have a chance to respond. And although the rule doesn't say anything about the applying party having a reasonable opportunity to make their application, the EAT in Onyx said that as a matter of, under the overriding objective, they need to be given a reasonable opportunity. So in Onyx, the respondent made a written application to the tribunal outlining their grounds, asking for an oral hearing to develop them, and the EAT simply said, no, we're not giving you your costs, without the chance of a hearing. And the EAT said that that was unfair. That was contrary to the overriding objective. They'd made it clear they had points that they wanted to develop. They should have been given an opportunity to develop them. Contrast that with Kite, in which the respondent also made a written application, also refused on paper, but that was all right. That was all right, according to the EAT. The difference was that in Kite, the respondent had given no clue in their written application that they had anything more to say on the subject. So the moral is, if you want an oral hearing, and I think usually if you're serious about it, you will want an oral hearing, make it clear in your application that it is only an outline of the submissions that you intend to make orally. We are not going to talk about wasted costs, partly because that is a subject in itself, and partly because successful applications for wasted costs are like hen's teeth. Although it is a three-stage test, which is set out there, which appears very similar to the test for ordinary costs in the tribunal, in fact, the threshold criteria is much higher. So, for example, drafting a wholly unrealistic schedule of loss, or supporting a client to pursue a hopeless claim or a hopeless defence, simply don't cut it. There needs to be evidence of an abusive process, which is directly attributable to the behaviour of the solicitor, and of course that's next to impossible to prove. Finally, at this stage, I just wanted to mention something about deposit orders, because in my view they are a much underused tool. They can be made at a private preliminary hearing. You don't need, so an ordinary case management hearing, you don't need a separate public preliminary hearing as you do for a strikeout application. And if they are successful and the claim fails for the reasons set out in the deposit order, then there is a presumption that one of the great gateway criteria for making costs order, a costs order has been met. So you are a good way along the road to getting a costs order. You will also have, if you make the application, you will also have some important information about the claimant's means. So you will know whether an application for costs is likely to be commercially worthwhile when it comes to it. And you will be in a better position to persuade a tribunal to deal with it immediately after a judgment if the costs, if the claimant's means have already been looked at. And finally, even if your costs application is not successful, if you've got a deposit order, there is the consolation prize that you get the deposit paid to you automatically. If the conditions are satisfied, there is no discretion to return the deposit to the paying party, and you, the receiving party, receives it. So that's all from me as an introduction. I'm now going to hand over to Andrew to talk about the gateway criteria.
Thank you, Dominic, and I should begin by extending an apology to you for leaving you on mute for several minutes. Having assured Dominic that I was on top of the technology, I managed to singularly fail with the most basic starting point. However, putting that to one side, as Dominic says, I am going to deal with the various costs, grounds, or gateways, as one might call them. So they are, as you can see from the slide, as follows. Insofar as Rule 76(1) is concerned, a tribunal may make a costs order and shall consider whether to do so. I emphasise both those things, where it considers that any of the following circumstances apply. The first is, as you can see, if a party has acted vexatiously, abusively, disruptively, or otherwise unreasonably, that's 76(1)(a). Secondly, that a claim or response had no reasonable prospects, that's 1(b). And thirdly, that a hearing has been postponed or adjourned on the application of a party made less than 7 days before the date on which the relevant hearing begins. That's 76(1)(c). Separately, in Rule 76(2), we have a further provision in respect of postponement or adjournment and indeed breach of an order. But in that circumstance, we don't have the 7-day rule. A few observations, overarching observations about 76(1)(a) to begin with before I get into the individual terms, vexatious, abusive, and so on. First of all, what one needs to demonstrate is that the conduct of a party in bringing or defending a claim or continuing to pursue it is unreasonable, as distinct from conduct occurring prior to the proceedings. I've mentioned the case you'll see there of Davidson, which illustrates the point. In that circumstance, an employer had conducted a dismissal process, which was, on any view, wholly unfair. That fact of itself would not warrant a costs order being made on this rule. Under this rule, certainly it may under a different rule, to which will come later. Perhaps Dominic will say more about later. But the unreasonable conduct was triggered by the point at which the claim was issued. And at that stage, the employer failed to assess the merit of the claim and continued regardless. There is also a distinction to be drawn between conduct which is occurring within the proceedings and out with it. And there is a degree of grey area there, which there is some case law about as to when the cost provision will be triggered and when it won't. And I've mentioned the case of Balch and Chipman. Essentially, it gives an example of where, or a distinction between a circumstance in which some abusive messages are posted. It could be on social media, it could be in a different circumstance, speaking generally for a minute. If those messages are specifically in relation to the proceedings, for example, seeking to intimidate a witness from giving evidence, then that almost certainly would come within the scope of the provision. If, on the other hand, these are merely abusive messages generally, then they may well not do. So those observations apply to the 76(1)(a) criterion, to each of the terms on the 76(1)(a) criterion. Turning to the first term, which is vexatious. So an oft-quoted citation from E.T. Marler and from Sir Hugh Griffiths on the meaning of vexatious. And you can see that what he said there is that if an employee brings a hopeless claim, not with any expectation of recovering compensation, but out of spite to harass his employers of some other improper motive, he acts vexatiously. So notice the emphasis on motive. If we come to, I was going to say a more recent case, but I'm bearing in mind Dominic's observation about us having done this for 40 years. I see it's probably it's nearly a quarter of a century ago, so perhaps it's not best described as more recent, but or recent, but it's certainly more recent than Marler. where Lord Bingham said this: vexatious is a familiar term in legal parlance. And then this: the hallmark of a vexatious proceeding is, in my judgment, that it has little or no basis in law, that whatever the intention of the proceedings may be, its effect is to subject the defendant to inconvenience, harassment, expense, etc. So there is a subtle but significant movement there, I would suggest, from motive to effect, which is worth bearing in mind when considering an application on this ground. That having been said, it's certainly my experience is that applications made on the basis that conduct has been vexatious, that term specifically, are pretty infrequent. More often than not, employment tribunals tend to use to focus on cases in which conduct has been unreasonable. And Kesgar is an example of such a case in which it was a race discrimination claim, and the conclusion was that there was virtually nothing to support the proposition that there had been race discrimination. Instead, it was a claim brought out of resentment and spite for unconnected reasons. And the conclusion reached was that that amounted to unreasonable conduct. On the face of it, it seems to me it could just as easily have been brought on the ground of it being vexatious conduct. However, as was made clear by the EAT in Bayne, in reality, whichever of the terms set out within 76(1)(a) is apt to apply, so long as one of them is, it doesn't really matter too much which label the applicant attaches. So we don't need to get too hung up on whether it's vexatious, unreasonable, disruptive, etc. Insofar as the next term is concerned, abusive or disruptive, again, there's no definition of that within the rules. Again, my experience certainly is that such applications are few and far between. Speculating as to what might amount to abusive or disruptive conduct in the employment tribunal, I've given you a number of things that spring to mind: excessive prolixity, time wasting, unduly lengthy cross-examination, which I'm certainly never guilty of. I don't know about you, Dominic. Overly aggressive cross-examination, calling unnecessary witnesses. I won't read them all out, but one can think of things. Plainly, that's just a few examples I've come up with. There's not a finite list. But the principal ground, certainly my experience, on which an application is made under 76(1)(a) is unreasonableness. And what is clear is that employment tribunals have a very wide discretion as to what unreasonableness might be. There are three areas which struck me as being certainly the most common that I encountered, so I'm going to touch upon each of them. The first is knowingly pursuing a hopeless claim. The second is unreasonably refusing an offer of settlement. And the thirdly is a late withdrawal of a claim. So taking those in turn, insofar as hopeless claims are concerned, it is perfectly legitimate to bring an application for costs on the grounds that it was unreasonable for a party to bring or conduct an unmeritorious claim. Note that does beg the question. In fact, there's a question that I was discussing with Dominic just before we came online as to where the distinction lies or what the advantages are as between such an application and an alternative application on the basis that the claim had no reasonable prospect of success. I think our joint view was, well, it makes sense to bring both and leave it to the tribunal. In the case of a no reasonable prospects application, of course, it would be an objective test, as I'll come to in a minute, whereas in relation to an unreasonableness application, it's not quite so simple. As you'll see from the second bullet point, what the tribunal want to know or want to see established is that either the party knew that his claim was unmeritorious from the start, or at any rate, per Cartier, that they ought to have known if they'd gone about the matter sensibly. My personal experience is perhaps one is more likely to recover a greater quantum of costs if the tribunal forms a view that the other side's acted unreasonably. But apart from that, and as I say, the objective nature of a reasonable prospects application, it seems to me you bring both and see where the chips fall. On the subject of what a party ought to have known if they'd gone about the matter sensibly, there is some case law that makes clear, as perhaps it's not that surprising, that a tribunal needs to be cautious about looking on hindsight at what the party ought to have known, when of course an employment tribunal, having heard all the evidence, may have seen things and learned things that weren't immediately apparent to the party at the outset. So bear that principle in mind. I've mentioned Kescar. In that case, the Employment Tribunal made what I think is, in retrospect, a fairly obviously flawed statement that it's not relevant, that the claimant didn't know that there was essentially nothing to support his allegation of race discrimination. It's plainly an obviously irrelevant factor. Turning to circumstances in which a party has lied, Daleside Nursing Home is certainly the case I see most frequently cited in relation to this, and the nub of it is that a manager was accused of making an explicit and highly offensive racial remark. The tribunal concluded as a fact that did not happen. It wasn't true, and it was central to that finding was central to the tribunal's wider conclusions about that manager. Despite that, somewhat extraordinarily, in my view, the Employment Tribunal went on to conclude, when faced with an application for costs, that the claimant hadn't acted unreasonably and she'd merely been wrong, and as a result, she'd lost the case. The Employment Appeal Tribunal didn't have much truck with that, and Mr. Justice Wilkie, as you can see, said that in a case such as this, where there is such a clear-cut finding that the central allegation of racial abuse was a lie, it is perverse for the tribunal to fail to conclude that the making of such a false allegation at the heart of the claim does not constitute a person acting unreasonably. Emphasis on the centrality of the lie. Evidently, if there is a tangential lie, then the principle is less easy to apply. That case led to a lot of people making allegations, making applications on the strength of allegations said to have been central that were found to be untrue, and there was a degree of rowing back from it. In this sense, in Arrowsmith, Lord Justice Rimmer endorsed an obiter comment of Mrs. Justice Cox made in XCA, which was not a case about lies. For what it's worth, she was making some general observations in the context of an application in relation to credibility grounds, but nevertheless, she rode into this territory, and Lord Justice Rimmer and Arrowsmith agreed with what she said. And what Mrs. Justice Cox said, as endorsed by Lord Justice Rimmer, is this: it will always be necessary for the tribunal to examine the context and to look at the nature, gravity, and effect of the lie in determining the unreasonable. So again, nature, gravity, and effect, plainly the emphasis on how significant is this lie to the proceedings. And perhaps not surprisingly, the Court of Appeal in Arrowsmith said that it's a fact-sensitive exercise, and a decision in another case in what might superficially appear to be circumstances similar to those of the instant case will not dictate the decision in it. In other words, the proposition that it will almost invariably lead to an order for costs is going too far. However, certainly my experience, and I have made such applications successfully on more than one occasion, is that again, if you have the tribunal has heard the matter as you ought to have, making a decision on costs, if they have found that a party has lied to them, then often one is pushing an open goal, certainly on the principle. Maybe the quantum is a different matter. In terms of withdrawal of the claim, for those of you who also deal with civil matters, you'll be familiar with Rule 38.6 in the Civil Procedure Rules, and in short, effectively that provides that if you withdraw the claim, you can expect to pay the costs. In simple terms, that provision doesn't apply in the Employment Tribunal. And indeed, in Macpherson, it was expressly said by the Court of Appeal that the mere act of withdrawing the claim shouldn't be equated with unreasonableness. So you can't start from the proposition that the fact that claim has been withdrawn means that you're onto a winner in terms of making a cost application. Instead, what you've got to show, looking at the conduct as a whole, is that the claimant, or indeed the respondent's conduct, has been I suppose if it's a withdrawal, it would be the claimant, but it nevertheless has been unreasonable in some way. And significantly, it's only at the point at which the conduct becomes unreasonable that the costs application it's only from that point that an order for costs can be made. And in Macpherson, I'm conscious of time, but in Macpherson is an example in which a claimant made a late application for a postponement on medical grounds. It was granted without much evidence, and perhaps that in and of itself wasn't the right way to go about it, but that's another talk. and it later proved to have been unjustified. He then, at the postponed or 2 weeks before the postponed hearing, he withdrew the entirety of the proceedings. He was able to recover costs from the point of the unjustified, in retrospect, medical postponement application, but he wasn't entitled to costs before that. In terms of refusal of an offer of settlement, I think Dominic's going to say a little bit about this too. So briefly, just as there isn't a general principle in the ET that one can recover one's costs if a claim is withdrawn, nor is there a general principle that if you don't beat a settlement offer which is made without prejudice as to costs, that there is going to be any adverse costs order made. Again, it's a fact-sensitive issue. The tribunal has got to first conclude that the conduct was unreasonable before the rejection becomes a relevant factor. That's 76(1)(a). One thing that struck me, and again, something Dominic and I were just briefly talking about before we came online, is the principle that one is entitled potentially to seek a finding in an unfair dismissal claim, for example, that one has been unfairly dismissed, even if the claim has little monetary value. And I just was speculating as to how that might interact with an application on this ground. I float that as something to think about. I'm not sure there's a clear answer to that question. If you're going to be making an offer of settlement, I would suggest that you make clear it's made on a commercial basis, if that is the basis upon which it's being made. Otherwise, the fairly obvious risk is that the other side turns around when you make your application for costs in respect of prospects, and say, well, how can you argue that had no reasonable prospects when you're making us offer a settlement? So it's important to emphasise that it is a commercial offer that is being made, as it often is. In terms of reasonable prospects, briefly, it was only in 2013, actually, looking back on it, that the rules created a dichotomy for the first time between an application focusing on conduct on the one hand, which I've talked about, and this application focusing on the weakness of the claim. And as I mentioned previously, in a prospects application, one is concerned with whether the claim was objectively unmeritorious, leaving aside the question of what the claimant ought to have known had he or she gone about the matter sensibly. That's per Vaughan. Having said that, Dominic's going to talk about discretion in a minute, and at the moment I'm purely concerned with the gateway. Evidently, I would have thought it's likely to be quite relevant to the question of whether a cost order should be made once one gets to the question of discretion, whether the claimant ought to have known that the claim lacked merits, or indeed did know, but no doubt Dominic will come to that in a moment. In terms of the final 76(1) rule, this particular one being 76(1)(c), when it comes to postponement or adjournment, an employment tribunal must consider whether to make a costs order if a hearing is postponed or adjourned on the application of a party made less than 7 days before the relevant hearing. Worth bearing in mind, as I said, there is also under 76(2) a further provision in respect to postponements or adjournments, which is slightly different. So this is where one is out with the 7-day period. In that circumstance, if a party makes an application for a postponement or an adjournment, then the employment tribunal may make an order for costs, but it isn't obliged to consider doing so without an application. In the rule under 76(2), importantly, per Ladbroke, is not linked to any vexatious or unreasonable conduct. This is about compensatory or compensation, not punitive order. So, and certainly, again, my experience is this is an area in which there is often scope to persuade an employment tribunal to make an order for costs. Again, evidently it's fact sensitive, and if there's good reason for the postponement, then one might not get very far. But if there isn't, then I certainly find tribunals are often sympathetic, and it's worth having in mind those two cases in particular of making such an application. And then finally, as far as 76(2) is concerned, one can also make an application if the other side has breached an order or practice direction. I think that's fairly self-explanatory. And then there's a very specific provision which you may be familiar with already in respect of an adjournment of an unfair dismissal final hearing in circumstances in which, this is Rule 76(3), in circumstances in which the claimant has expressed a wish to be reinstated or re-engaged, respondent's been told about it not less than 7 days before the hearing, and despite that fact, the hearing gets postponed or adjourned because the respondent hasn't dealt with it properly. In those circumstances, the employment tribunal will make an order for costs. I can't say I've experienced that particular provision being applied for what it's worth. And on that note, I'll hand back to Dominic.
Thank you, Andrew. We now got to the stage where the gateway criteria has been made. The tribunal is satisfied that it is entitled to make a costs order. And so I'm just going to talk about the factors that it might bear in mind when it's considering whether it should do that or not. And the first thing to say about this section is that it comes with a significant health warning, which is that the EAT has repeatedly said that tribunals must take an overall, a broad overall approach and should not be distracted by previous authorities. So although I'm going to refer to lots of previous authorities, they should be treated as previously decided cases, examples of what had happened in certain factual scenarios. They shouldn't be regarded as authorities. Mr. Justice Griffiths put it like this in the Bardwaj case: costs awards did not operate by precedent, but were fact-specific and had to be determined as summarily as possible, that the expectation had to be that nothing more than the words of the relevant rule required addressing before the employment tribunal exercised its discretion on the facts of the particular case. And having said that, the EAT has felt able to criticise employment tribunals for taking into account factors which they shouldn't have done. So, for example, in the Tresca case, the employment tribunal found that the claimant had only pursued his discrimination claim as a device, but that hadn't been alleged by the respondent, and so it wasn't an appropriate factor for the tribunal to have taken into account. Similarly, in the Chewinberry Farm Hotel case, part of the reason the employment tribunal said for making the order was to deter employees from bringing further claims. And again, that wasn't a relevant consideration. So the costs order was set aside. On the other side of the coin, if the tribunal fails to take into account a factor which they should have done, then that also will be an error. So in the Better Lives case, the respondent had played a significant role in the running up of costs. That was not something that the tribunal referred to in their cost decision, but it was something that they should have taken into account. So that costs order didn't stand. The last thing that you want to do is to end up in the EAT on the issue of costs, because that entirely defeats the object of the exercise. So it is really important, I would suggest, not to encourage the tribunal to take bad points, but equally, it might be appropriate, obviously with a light touch, to draw the tribunal's attention to factors which they need to bear in mind, but which might work against you. I'm just going to skip forwards a few slides, because the single most important factor in the exercise of the discretion, in my experience anyway, is whether a claimant has been legally represented or not. And that's not just because an unrepresented claimant can't be expected to know the law, can't be expected to know how to behave within the tribunal setting, but also because they can be expected to lack objectivity. So if you're going to succeed in a costs application against a litigant in person, you're going to have to show that they've gone beyond the mere inexperience. They've gone beyond what might naturally arise from a lack of objectivity, and you're going to have to show that they've behaved unreasonably or vexatiously, or whichever test you're applying, even by the standard of a litigant in person. The most obvious way of doing that is with a well put together costs warning letter. And you can, it appears, even rely on a cost warning letter that was sent in previous proceedings. But having said that, it will just be one factor. So the EAT made the point in the Acro case that parties frequently send cost warning letters to each other, and that slightly devalues their currency. So even in this case, which was a claim that was unreasonably pursued, a cost warning had been given, the tribunal was nevertheless entitled to refuse to make a costs order. should go without saying that you should only send a cost warning letter if the circumstances warrant it. Otherwise, you might be on the on the hook for unreasonable conduct costs yourself, or worse. And any letter needs to be carefully drafted so that it explains properly and in a way that the other party can understand why the claim or the defence, as it may be, is misconceived or unreasonable, or whatever the argument is. And your letter will also need to make the other party aware that their ability to pay may be a factor that the tribunal takes into account. Of course, there's no reason why you can't send more than one cost warning letter, as the circumstances dictate and as the evidence evolves, providing you are not hectoring. What about if you haven't sent a cost warning letter? That's going to make it harder, but it may not be a disaster. It's all going to depend on the facts. So in Rogers, the claimant's case failed because the tribunal had no jurisdiction to hear the sort of claim that he was bringing. The respondent had known that for many months. They'd known for months that this was a misconceived claim that was bound to fail. They could and should have given the claimant the opportunity to reflect on their position, but they didn't. And that was a decisive factor. So the absence of a warning letter in that case was the decisive factor against exercising the discretion in favour of a costs order. On the other hand, in Vaughan, the claimant was convinced, without any rational or evidential basis, that she was the victim of a conspiracy. And the EAT upheld a substantial costs order, even though there hadn't been a cost warning, because a cost threat, the reality is that a cost threat would not have made any difference in practice. She still would have pursued the claim to a final hearing. Didn't matter that there wasn't a cost warning. Same thing or similar thing in the Tohu case. The claimant was a professional man. He brought an earlier employment tribunal claim. He should have appreciated the seriousness of the allegations that he was making, and he should have appreciated the desirability of taking legal advice. So again, the lack of a cost warning in that case didn't mean that the tribunal was wrong to make the order that they did. By extension, of course, if the other party is legally represented, then the lack of a cost warning is much less likely to be a relevant factor, or at least a significant factor in the exercise of the discretion. And I've touched on deposit orders already, but one of their advantages is not just that they fulfill a gateway criteria. They are, in effect, the equivalent of a cost warning from the tribunal. So they usually carry a great deal of weight, often decisive weight, in favour of making an order. And if you don't seek a strikeout application, if you don't make a strikeout application or seek a deposit order, in some circumstances that might count against you, and that is what happened in the AQ and Holden case. Although, as Vaughan made clear, you might be able to explain why you haven't made a preliminary application, because you were merely trying to reduce costs and avoid delay. My view is that it is usually worth, in any case where you think that there might be a costs application, to apply at the preliminary hearing stage, at the case management stage, for a deposit order, because even if, as unfortunately very often happens, the employment judge runs out of time at the case management hearing to deal with a deposit order application, you will be able to point to it and say, look, we have made this clear from the outset. We tried to get a deposit order, but we ran out of time. And you may well get some general observation, even if the tribunal doesn't deal with the application in full. It's not at all unusual to get some general observations out of the judge, along the lines of, well, I'm not going to make this application today, Mr. So-and-so, but I have to say that I think the respondents have got a pretty strong case. I think you might want to go and take some legal advice. If you get a comment like that, you can make a note of it, and then you can put it in your cost warning letter, and it's there for the tribunal to see when it comes to the final application at the end. The only thing to bear in mind is that if you do make a strikeout application and it fails, or a deposit order and it fails, that might limit your ability to pursue a costs or order later. And although it's only a first instance decision, I've included the case of Hewitt there as a salutary reminder of the need not to use cost warning letters in an inappropriate case. So in Hewitt, the DWP was ended up with a preparation time order against it for 50% of the claimant's costs, because the judge felt that having refused the strikeout application, it was inappropriate for the respondents then to go on after that and send a cost warning letter. Where a party has taken legal advice, so this is not where I guess it applies where they're represented as well, but where they've taken legal advice, the assumption is that advice will be competent. So it will be difficult for a party defending a costs application to argue that they only pursued their claim because they've been following legal advice. And very often, legal advice is used by both parties as to where the exercise of discretion should go. It's difficult. It's much harder, I would say, for the defending party to use it. It's usually going to require a waiver of privilege before they can do that. And usually, if a party has taken legal advice, that is something that weighs in favour of the exercise of the discretion. And very often, employment judges, as I've indicated, will encourage litigants in person to seek legal advice, particularly where they claim they think the claim is misconceived or difficult to understand. Again, I think that's absolutely something that is worth keeping a note of and making a reference to in any costs warning letter, so that by the time it comes to a final hearing, you can show that it's not just you that's been telling the claimant to go and get legal advice. The tribunal's been doing it as well, and they've been sticking their head in the sands. Andrew touched on settlement offers, and I want to as well. Don't be afraid to make a commercial settlement offer in a case where you might be thinking of applying for costs. But as Andrew said, make sure you make it clear that it's a commercial offer and that it's because you're about to incur more than that in costs if the case carries on going. That way, the other party will not be able to argue that you can only have made the offer because the claim had merit, or I assumed that the claim had some merit because you made the offer. And you will be able to argue that you, as well as your cost warning letter or whatever, and all of the other steps that have been taken to draw matters to the claimant's attention, you have put them on very clear notice that you were about to incur significant costs, and that is why you made them an offer. If it is unreasonable for the claimant to pursue a claim at all, as the Rose case illustrates, it is even more unreasonable to pursue one in the teeth of a worthwhile offer from the other side. Aside from whether someone is represented or not, I think the nature of the claim is the other factor which plays most in the tribunal's exercise of its discretion. And that's because it is well recognised that in discrimination and victimisation claims in particular, the weakness of a claimant's case often doesn't become apparent until the explanation for the treatment complained of has been tested in cross-examination. So, for example, in the Oko Jaya case, the tribunal made a costs order on the basis that the claimant had all the potential evidence available, and that was overturned by the EAT on the basis that that was just wrong, because the claimant hadn't had the opportunity to cross-examine the respondent witnesses and didn't know how they were going to react to the questions that he was going to put. So essentially, for the same reason that strikeout applications are rarely successful in discrimination claims, that also applies to costs applications. But that said, in my experience, tribunals are more and more prepared to make costs applications, even in discrimination cases, particularly where claimants have ignored tribunal's advice to concentrate on their core claim and are pursuing much more far-reaching claims than is remotely reasonable. And something that I have had success with in long discrimination claims is to make a drop hands offer at the halfway point, and then to make a targeted application for the fees beyond that time. And because by the halfway point, or at some point in the proceedings, you get to a situation where the claimant has had their say, they've had a go at putting their case to some of the respondents' witnesses, and they may well be in a position to recognise that actually this is a hopeless case and it's going nowhere. And tribunals are much more ready, in my experience, to grant targeted applications for costs than they are, for example, to award costs for the whole of the proceedings. Very quickly, because I need, I think, to hand over back to Andrew, I've just made the point that serial litigants, or even if someone who's just brought a single claim in the past, that is a key factor in the exercise of the discretion. So worthwhile doing a Google search, and I set 3 examples of out of that there. And then finally, just some other factors which often come into play. So the blameworthiness of both parties. So the conduct of the paying party may only just have satisfied the Great Gateway criteria, or it may have satisfied them with flying colours. And it's obviously relevant to the exercise of the discretion where on that sliding scale they are. But as the Better Lives case shows, the receiving party's conduct may also be relevant to the exercise of the discretion. The ability to pay, Rule 84, that is relevant both, or is likely to be relevant both to whether you exercise the discretion at all and the amount of costs. I'm going to let Andrew deal with that in more detail on the amount of costs. Andrew's already touched on late withdrawal. Again, that late withdrawal can be a factor in the that plays into discretion in an unreasonably brought in a claim which lacks prospects, but the question is going to be, why was it withdrawn late? Was it withdrawn late because the claimant never had any intention of going to tribunal and was hoping to get some kind of offer out of the respondent, or was it withdrawn late because the claimant realised only at a late stage that the claim that he was pursuing was a weak one? And 2 contrasting examples of that on the slide. And then finally, from me, there is some suggestion in the Mardner case that the financial circumstances of the receiving party might be relevant, although that was quite an unusual set of circumstances. Mrs. Justice Easy said it was appropriate for the tribunal to take into account the fact that the trustees of the respondent were funding the case out of their own pockets, although in fact she set aside the costs order for other reasons. So that's all from me. Back to you, Andrew.
Thank you, Dominic. So turning now to the amount of any costs order, there are 5 aspects to this under 78(1), but the principal 2 are the top 2. They can make an order of their own motion for a sum not exceeding £20,000. And certainly my experience is I often recommend for in practical terms that it's appropriate to make an application that is limited to £20,000 when faced with a litigant in person on the other side who realistically probably doesn't have the means to pay more than that anyway. If you do want to seek more than £20,000, you're perfectly entitled to do that. But in that circumstance, it would be subject to detailed assessment. That is either done by the county court or now can also be done by the employment tribunal according to the rules. Though again, in practice, my experience is there aren't many. I'm not sure I've ever actually seen an employment tribunal judge do a detailed assessment. And certainly my understanding is that very few have actually been trained to do detailed assessments. So realistically, it's probably going to go off to the county court. We've also got C, tribunal fees. That's effectively historic interest these days. Witness expenses is potentially important to bear in mind. And E, a sum agreed by the parties. If you're on the end of a cost application, then you might want to try and agree something if you think you're at real risk and you're entitled to do that. In terms of the type of costs that are recoverable, according to Rule 74(1), they include fees, charges, disbursements, expenses incurred by or on behalf of the receiving party, and that, as I've mentioned, includes witness expenses. I'm often asked, can you recover in-house legal costs in the employment tribunal? You can. There's no barrier to that at all. As was made plain in Lodwick and other cases, any award for costs is made on a compensatory and not a punitive basis. So that's important to bear in mind. In terms of causation, in other words, the link between the matter entitling a recovery of costs and the amount of costs incurred, this can be tricky. And in Macpherson, I spot the deliberate error, Mummery LH there, as he is. In Macpherson, he said this, and he was quoted as he often is in lots of circumstances, frequently in relation to this. The principle of relevance means that the tribunal must have regard to the nature, gravity, and effect of the unreasonable conduct as a factor relevant to exercise of discretion, but that is not the same as requiring the receiving party to prove that specific unreasonable conduct caused particular cost to be incurred. So there was a view taken that suggested that there didn't need to be a particular link between the unreasonable conduct and the particular costs incurred. He went on to clarify in Yerra Calva that wasn't what he meant. And in fairness to him, before we look at Yerra Calva, if one goes back to what he actually said in Macpherson, he does use the word effect, the nature, gravity, and effect. So I don't think he ever intended to move away from a causative link in the manner that some perhaps interpreted to mean. But certainly in Yerra Calva, he made that even clearer, where he said the vital point in exercising discretion to order costs is to look at the whole picture and to ask whether there's been unreasonable conduct. And in doing so, to identify the conduct, what was unreasonable about it, and what effects it, another deliberate typographical error, had. So again, it's about the effect of the unreasonable conduct. There doesn't have to be an absolutely clear link between the two, but there has to be some form of link. In terms of the ability to pay, as Dominic said, I'm just going to touch upon this briefly. The rule is, and perhaps it surprises many, when deciding whether to make a cost order, and if so, in what amount, an employment tribunal may have regard to the party's ability to pay. There is often an assumption made that the tribunal must have regard to ability to pay. That's not actually what the rule says. Although, again, having said that, my experience is it's very unusual for a tribunal not to have regard to ability to pay. And if the other side raises it, then it's certainly going to be taken into account almost invariably. And as I think Dominic mentioned already, my advice when involved in a case in which I think a cost application might be made is to put the other side on notice of that, so that they can't turn up and say that they haven't got evidence as to means, thus preventing an application being dealt with there and then. As Dominic said, the ability to pay is relevant potentially to both discretion and quantum. If it does have regard to ability to pay, an employment tribunal is not restricted to assessing a sum that can immediately be paid. This is one of the more important things I would suggest to take away from this talk, and certainly it's a point I often rely upon when making applications against litigants in person, who will often say we've got no money. But if they're in their 20s, 30s, 40s or whatever, and they've got 20, 30, 40 years of work ahead of them, then there's absolutely no reason why you can't make that point. And in that circumstance, I've certainly had success in persuading a tribunal that even though the party at that point in time has no immediate funds, there is every likelihood at some point that they will come into money, and at that point they could start paying the order. In terms of serving schedule of costs, it's not strictly a requirement, which follows on from the fact that there isn't a strict need to give notice, I suppose. But certainly if you do know you're going to make an application for costs, my advice is it's worth putting together a schedule of costs, not least because it will make the tribunal's job easier. And again, in practical terms, if you make the tribunal's job easier, I suspect that the likelihood of getting what you want is probably higher. And as per the Abaya case, it enables the tribunal to fulfill its obligation to look at the sums and scrutinise what's actually being claimed. Going back somewhat conversely to what I said a moment or two ago about limiting cost applications to £20,000, if you think that that's the wise thing to do in view of what you might recover, what an employment tribunal mustn't do is take the view that it's going to make a summary assessment, in other words, limited to less than £20,000, simply because that avoids detailed assessment. If that's not what the application requests and not what is appropriate to properly compensate for whatever conduct it is that warrants the cost order. In terms of detailed assessment, as I've mentioned already, my experience certainly is there aren't many EJs who are able to deal with such applications, and therefore it's likely to go to the county court. That begs the question, should the employment tribunal take a view about whether it's costs on the standard basis or indemnity costs? Very unusual. And again, I'm struggling to think of a case where I've seen an indemnity cost order made by an employment tribunal, but they are in theory entitled to make such an order, send it to the county court on the basis of indemnity costs being recovered. But as per the Howman case, it's made very clear that that's going to be a very rare circumstance. In other words, not only are you going away from the starting point that costs are the exception, very much the exception in the employment tribunal, you're going to have a case in which the conduct justifying the award is so egregious as to then move towards indemnity costs. But it's worth bearing in mind if you have such a case in front of you. And then a couple of more fairly minor esoteric points. If you've got a claimant who's entered into a DBA, bear in mind that they can only recover costs to the extent that they will be the beneficiary of the order. So if you suspect there's a DBA involved, it's a question worth asking. And certainly there are plenty of DBA cases still floating around in the employment tribunal, in my experience. And in terms of VAT, the position is equivalent to that in the county courts. It shouldn't be included in a claim for costs if the receiving party can recover it as input tax.
Well, thank you all very much for your time. Thank you, Andrew, for your help. And,
all that well, in the case of the audio functioning.
And we'll wish you all a good afternoon.
Yes. Good afternoon, everyone.